In this video, I'm going to be talking about probation violations in Indiana. A lot of times in a criminal case, a person may end up on probation after a sentencing. And what we're going to talk about is what happens if probation files a violation and says you violated some of their rules and conditions. So about me, my name's Nathan Vining. I'm a criminal defense and family law attorney here in Indiana. And hopefully by the end of this video, you can know a little bit more about what you can do if you find yourself with a probation violation. So probation in Indiana is essentially an alternative sentence. If somebody is found guilty or pleads guilty to a crime, a lot of times they could serve time in jail. For instance, if you're convicted of a misdemeanor, you may face up to a year behind bars. But a lot of times what you may end up with is what's known as a suspended sentence. And that means that you do not have to do that time, but that time may be hanging over your head, so to say. And oftentimes when you have a suspended sentence, you're placed on probation. And what that means is that you're supervised by the county probation department as an alternative to full incarceration. So it allows you to serve your sentence while remaining in the community, subject to certain conditions and supervision. So for example, a lot of those would be not committing further crimes, not consuming drugs or alcohol, completing certain remedial courses such as a substance abuse assessment classes, anger management, behavior modification courses, things like that. So ultimately that's what probation is. And if you're on probation, you have that time hanging over you, that suspended sentence. So if you violate, a lot of times the probation department may issue a formal violation which is filed in your criminal case. And you would get notice of it and you would have a right to hearing, because ultimately the court can issue additional sanctions as a result of a violation. So the probation violation can ultimately have serious consequences because the judge can give you all or some of your backup time or place additional restraints on your sentence. So some of the common conditions of probation of Indiana would be reporting to the probation officer. Typically there would be a monthly meeting with the probation officer. You may also be directed to report as requested. You may be requested to maintain suitable employment, attend educational programs, adhere to travel restrictions like not leaving the country or state without permission, undergo counseling, drug and alcohol testing, curfew requirements, as well as there are certain fees and fines as a result of probation. If you are violated, essentially it's the violations filed in the court case. There would be a summons or a warrant issued. Sometimes there's a summons issued where you're just provided notice of a hearing. Other times, depending on what's being alleged, the court may issue a warrant for your arrest. If that occurs, I highly recommend contacting an attorney because the attorney may be able to recall the warrant and actually get you the ability to self-report for a hearing. If you are facing a violation, you also have a right to a hearing, a right to counsel, because you would potentially be facing the consequences of jail or other sanctions. And then you have a right to a hearing where evidence by the state would be presented in the probation department where they're alleging what you violated, and you have the right to present your own witnesses and defend yourself in that hearing. One important note, though, is that the consequences of failing to pay fine, fees, and costs, it can't be the sole basis of a probation violation. A lot of times when somebody hires me for a probation violation, the big question is am I looking at jail? And there's a lot of factors that go into it. One is just the severity of the violation. Did you commit a new offense? Did you abscond and leave the state for a while? Do you have a history of violations in this or other case? There could be aggravating factors like, was there harm caused in the violation? And then there's also mitigating factors. A lot of times you may have a great relationship with the probation officer, you're on the right track, and you just had a simple slip up. And then there's the judge's attitude. There's a lot that goes into what a judge's view is on a certain case and a violation. A lot of judges say, I'm strict compliance from day one, and if you mess up, you could be facing all of your backup time. And there are judges that will do that, but also it's important to hire an attorney to understand specifically who you're in front of and that judge's attitude to understand how to best present your case. So again, this is just similar. What are these factors? It can be weighed differently anytime. Sometimes somebody may get picked up on a warrant for a probation violation, and they may sit for 2 weeks, a month, sometimes 2 months while you're waiting for the evidentiary hearing. And sometimes you may be able to argue that those 2 weeks or the month is an appropriate sanction and that you should be released back onto probation and on strict compliance. So ultimately, if you're facing a probation violation, there's a lot of strategy that goes into it, down to what judge it's in front of, what do you want to argue as maybe a sanction, and then also, are you even guilty of it, and is there a defense to be presented on a factual basis with evidence that you can come forward with? So if you have questions, feel free to give me a call. Again, I'm Nathan Vining. I'm pretty available by phone or text, and I'd be happy to review a case if you're looking at a probation violation.